Right. Thank you, everyone. Those who've been able to join us, I hope that you can hear me clearly. Please confirm that you can hear me clearly. Right. Brilliant. So today we're going to discuss intellectual property basics for your startups. The whole idea with intellectual property and the ownership of intellectual property is that for a startup, this is the knowledge. Susan, please mute. Thank you. Susan, thank you. All right. So the whole idea with intellectual property is that intellectual property is the mental, or rather, intellectual property is the creation of the mental creations that we have within our startups. This is how startups make their money, and this is ideally what you need to protect. And there are various types of IP. Today we're going to discuss what IP is, what are the laws around intellectual property, what are the types of intellectual property. We're also going to discuss intellectual property across various industries within the startups, and we're also going to discuss the benefits and the commercialization of intellectual property. Finally, the strategy that we can have in order to enjoy the benefits of IP, and then we're going to have a Q&A session. Now, hopefully you're going to use at least 40 minutes for this presentation, then we can have at least 20 or 15 minutes for the question and answer session, just like last time's session. So now, what is intellectual property and why is it your startup's most valuable asset? So intellectual property is the legal rights granted to you as a creator or as a founder over the creation of your mind. This will enable you, you as an individual or the company to control, to protect, and to commercially exploit your innovation, your creative work, your brand, and your confidential information. So IP is basically your asset within what you have created. You as a startup founder may have created a system, you may have written code and have software which can be copyrighted as intellectual property that you may protect. You may license it out to make you money. You can have your trademark that you can protect. You can have your trade secret to be protect, and you can use all of those elements of IP to raise your revenue. Now, investors also usually look at IP to compare and see whether your startup is investable, to see what you have protected, what you have licensed, what you own, and what assets that you have as a startup founder within your business, where intellectual property is an asset. Now, when you have strong intellectual property and you've been able to protect it, you're able to prevent a lot of copying of your ideas and protect your business interest in advance. Now, how can you raise money through intellectual property? This is through royalties. This is whereby, for example, musicians, they usually earn royalties once you exploit some of their music, or movie directors once the movie is used by Netflix on their various sites, and then you're able to earn royalties as a creator. Then you can also have licensing. This occurs, for example, where Microsoft, the Microsoft license, the Word license that we pay, the annual, is it 12,000 per user thereabouts, or even LinkedIn. When you use their platforms, they've given us a license to the intellectual property, so we pay them, and then we're able to exploit it, and then you can make money. And that's also how various businesses also make money within the digital space. Then there's franchising. This is whereby you look for, I think the best franchising model that I would give would be KFC. So Colonel Sanders in the US still makes his money from the KFC in Kenya through creation of a franchise model, whereby people apply to be part of a franchise, and then they're able to, earn revenues or through the franchise. So that's basically a simple overall look of what intellectual property is. So this is basically your legal right as a creator over your creation. So now, IP as a business asset, these are some of the examples that we may have. We have Microsoft. So Microsoft has software licenses and patents. This is through the Windows operating system, which it gives to manufacturers. Then we have Office 365 subscriptions. So this is whereby you use Excel, you use OneDrive, you use PowerPoint as we're using today. So these subscriptions that we usually have generate billions in revenue. This is how you can utilize intellectual property. Now, when people use cracked software or jailbreak software, that is a risk of usually and a violation of the Microsoft license that's usually granted to individuals. Then we have Apple with the iPhone trademarks and the patents and the design marks that they have. So they have a lot of design marks in the MacBook Air, the utility patents, the trademark portfolio. So now you cannot go out there and use the Apple logo, which is protected, and for your own, private uses without getting either a cease and desist or getting a mandatory license for the same. I think I had a concern. Is there a hand raised? I cannot see. All right, no problem. Then we have Google. We have Google algorithms, and we have data. Is there a question? No question. All right. Thank you. Then we may proceed. Please confirm that you're seeing the full screen presentation. I think I lost the presentation. All right. Back. Great. So now we already know intellectual property is an asset of these businesses. Where we have now Google, whereby Google also has protected its IP, its algorithms, and its software through Android OS, even AI models, and all IP assets. And then we have Pfizer also, which has protected its pharmaceutical patents for drugs, and that's how they make their money through research and development. Right. So Pfizer, Google, Microsoft, all these different companies usually make their money through patents, through designs, through various protection mechanisms, as we've just addressed. Now, I keep losing the screen when I try to project. I don't know. Let me see if there's something I can do to sort that out. Give me a minute. Right, and we're back. So we have discussed some of the business applications for these startups and how they use intellectual property as an asset. Now we also have the legal framework that we have in Kenya, whereby we have the statutes, the international treaties that govern intellectual property. One, we have KIPI. This is the Kenya Industrial Property Institute. This governs patents, utility models, industrial designs. Then we have Kekobo. which governs copyright registrations, administration. This is whereby we have ratings such as, the source code. This is covered by copyright. Patent and utility models. This usually covers the physical designs. If you're a hardware company, then you need to protect it as a patent. Then we have the Anti-Counterfeit Authority, which enables enforcement of the intellectual property protections. So some of the acts that we consider, we have the Industrial Properties Act, which governs patents, utility models, the Copyrights Act, which governs creative works, then trademarks, which governs the protection of trademarks. So an example of a trademark would be your company logo or your company name, which you would, protect as a trademark to ensure that no other company registers with a similar name and uses your brand so that they can pass off as you guys. Then in the international level, we have WIPO and we have TRIPS, whereby intellectual property is recognized on an international level. Now, we also have the various types of intellectual property that startups need to understand. So we have patents. A patent is usually granted to an invention. So when you invent something, then you get a patent. So the idea is for something to be patentable, it has to be novel. Novel means new, that it has not been previously disclosed somewhere else. Then you must have an inventive step. That means that you must invent. It must not be very obvious. So for somebody who is in a field, when they create an inventive step, an expert within that field may not just outrightly think about that thing very easily. Then the third and most important, it also must be applicable in industry. So for example, these are some of the things that can be patented: medical devices, biotechnology, things that are used in the medicine space, mechanical machine, pharmaceutical compounds, software that has technical applications. So you can only patent software whereby the software has a mechanical application or is interlinked with a hardware part. So protection for patents is usually within 20 years, but that's not usually a big problem because technology changes. I think it's usually Murphy's Law, technology changes every other 2 years. Now, ideally, we can discuss maybe how Pfizer has been able to use patents. So usually, a new drug developments usually costs around $1 to $2 billion, according to Pfizer's research, and it takes around 10 to 15 years. So in order to protect companies, what intellectual property laws do is that you patent your pharmaceutical product and you can use exclusively the product for 20 years. However, some countries have, very different IP protection regimes, such as in China, whereby in China, they try and prevent, they don't have very strict patenting laws, especially around medicine and drugs. So you find that once you generate a product, they just, create a copy-paste of the product in order to have commercial benefits everywhere. Now, an example of the drug is like Lipta. Lipta generated $130 billion lifetime revenue for Pfizer. But if you look at the investment of $1 to $2 billion, it already makes sense for them. Then when you patent within the research and development phase, no other companies usually can use the same. So now even for you as a startup, if you're either in the pharmaceutical sector or you're in sectors that require technical measures, it's important that you consider this. Then we have trademarks. Now these ones are usually the most important regarding brand protection. So these ones are usually renewable indefinitely. So a trademark would be like, you can trademark your name, your brand. Even as a musical artist, you can trademark your logo, your logo, your symbol, your tagline. If you have a distinctive tagline, your sound. For example, the Netflix Tudum is usually trademarked, so that if you hear the Tudum, you really know that this has to be Netflix and nobody else but Netflix. Now, an interesting case study would be Coca-Cola. So Coca-Cola is one of the most recognized brands. So they've protected themselves and trademarked the Coca-Cola name, the script logo, the red color, the bottle shape, and they renew every other year to ensure that the trademark is available indefinitely. And if you decide to create a brand like that looks like Coca-Cola and you call it the same, what will happen is you can easily get sued. So now the formula now has been protected as a trade secret. So the Coca-Cola formula, when you protect something as a patent or as a trademark, you have to disclose it. But when it's a trade secret, you do not disclose it to the patenting or rather to the IP protection authority. So now, if you protect something as a trade secret and you know that if you reveal this as a trade secret, other companies are going to use it, or you cannot really, a secret cannot really be, called a secret unless you don't disclose it. So now, ideally, what Coca-Cola has done is that they have that as a trade secret. Now we have copyright. Copyright usually comes in when you want to protect software code, music, written content, and artistical work. So now, no registration is necessary for copyright. However, when you register with Kikobo, you usually have a duration of 50 years. So now, if you write your source code, you can copyright your software source code. You can register it, you can also refuse to register it, but once you have created it is copyrighted, it is yours. The other thing with the trade secrets, these are examples what I just told you about Coca-Cola. So they are confidential business information that provides a competitive advantage. So now, as a startup founder, they are usually the competitive advantage that you usually ask when you're doing pitches. So there are things that you can protect, such as your algorithms and data models. For example, in Google DeepMind, the algorithms that they use, they would have protected them as a trade secret to attain the competitive edge. So recipes, formulas, manufacturing processes, and even business strategies can protect them as trade secrets. And when you protect them as trade secrets, what you do is you do contracts with the members of your team that are involved through NDAs, confidentiality clauses, restricted data access, employee agreements, and various methods by which you can protect. Then you also have the industrial designs. So what are the industrial designs? Industrial designs usually think about the shape of the product, the shape of the Coca-Cola bottle, the surface, how does it look, what are the combinations of the colors, what are the graphical interface. So now you can, for example, with Apple, the curved, they have edges that are usually very well carved and similar. If you put your iPhone and your AirPods case and your MacBook and put them on one corner edge, you'll notice that that shape is very unique and it is very similar. That the interface and the product at that edge is very, it's one similar shape. So Apple has been able to protect this as an industrial design, as an aesthetic of the product, such that if you decide to copy paste it and do it, they can sue you for infringement. Now we also need to discuss how different sectors handle intellectual property. So within the technology sector, we discussed this, whereby we talked about copyright, patents, and trade secrets, how you can copyright your source code, how you can patent your technology if you're using a hardware product, and the trade secrets that you can have. In fashion and consumer brands, you can use trademarks and industrial designs. You can use trademarks and industrial designs to protect your logos, your trade names, the distinctive appearance of your products, the Adidas logo. In the pharmaceutical space, you can use patents because you would want to prevent other people to at least copy-paste your product for 20 years. In media and entertainment, copyright is what is dominant. It's in the books, in the writings, in the games, and even in the licensing that you can have. Now, what are the benefits of commercializing IP and how can you do it? So IP is a strategic asset. How do you commercialize it? So first of all, the benefits of commercializing would be that it would give you a competitive advantage and you'd get investor confidence. You would be able to generate revenues. You'd have an increased valuation. You can scale internationally because IPs are also protected internationally. Then you can leverage partnerships whereby you can assign or you can give a license to a third party to become a distributor. An example of companies that have done this is Odoo, the ERP system company, whereby they have licensed third parties, or rather they have given them an assignment that they become a redistributor of their technology. Now, as a startup founder, if you want to think about IP assignment and what it is and how you would be able to do it. So this is usually a transfer of ownership of your IP. So usually when you have your team developing for you as a startup founder, you would want to consider how you would want the intellectual property to be handled. Now, the employment contracts, if these are employees, should clearly outline that this intellectual property belongs to this business, and this intellectual property is not your own, such that the IP that they generate using the work laptop and the work that they do within the company hours becomes the business and the ownership of the company. Now, if you do not have such strict clauses, you can get into issues whereby employees can come and claim and say, hey, look, as a matter of fact, this IP does not belong to the founder or to the company, but it belongs to me. So now the due diligence that is required when you consider things such as assignment is that the contracts that you have within the team, how do they look like? Before an investor commits capital, when a co-founder decides to leave, how are you going to discuss the intellectual property that the co-founder created without assignment? So that separation agreement, or even the shareholder agreement that you usually have, how are you going to discuss the ownership of the intellectual property? And then also employees who develop IP in the course of employment, ordinarily that IP should be yours, and you need to have that clear cut within your contract. Now, ensure your agreements even with third-party contractors, whereby you have hired somebody else to do work for you, and assign an assignment of the third-party contractors, how are you going to assign those intellectual property? Or even you as a developer, or as even as a lawyer, when you've been contracted by a third party to develop work for them, how are you going to handle that IP? Verify the ownership of the intellectual property. Read through those contracts that you generate with them. Ensure that you have NDAs to conserve sensitive intellectual property, especially things like trade secrets. You don't want people to be knowing the creative juice of your startup before you even have had an opportunity to exploit it. Now, these are the various ways in which you can make money through commercialization. So you can have various licenses. You can have an exclusive license. This is whereby you tell one company or one company or one individual that they have the exclusive right to use their IP. So they pay you a premium, and then you don't sell it to anybody else. Usually this occurs especially when you have a partnership. Maybe you have maybe you're an advertising business and you want to have a partnership in maybe a different country like Uganda, so you can give them an exclusive license. You give one company an exclusive license to distribute your intellectual property within that country, and you don't issue the same license to another company. Then you can also issue it within an exclusive license, whereby you can have different parties using the same IP simultaneously. An example of this would be how SAP has done. So SAP, it's also another ERP company. They have different vendors, whereby they have given them an exclusive license to redistribute their software. Now, for example, even Windows, we have many companies that install Windows, even the 365 business suite for different organizations. So the license that they have is usually an exclusive. Then you can have a cross license. This is whereby companies exchange rights to use each other's patents. So, for example, you can be having complementary portfolios. An example of this would be Samsung's phone division and Samsung's RAM division, whereby you find that the phone division and the RAM division can have a cross license, whereby they use similar technologies, rather complementary technologies. We need this from you and you need this from us, so let us just have a cross license for usage. Then we can have We can have the free license, the open license. The open license or the free license is usually given with when systems are open source. This is like what has happened in Linux. And then we also have the franchise license. This is what is happening with KFC. So whereby KFC decides to look for, you approach KFC or KFC approaches you, you give them some money and you're able to sell KFC products, and then you make money, such as because they have already built the brand for you and the whole business model and the business structure. All you do is you make profits being a franchisee of them. This is very similar in retail spaces in various ways. Then there's technology transfer. This is usually in IP that is developed through research. So you do a formal technology transfer agreement with third parties. Now, Microsoft, we discussed this, an example of how Microsoft has been able to build one of the most profitable businesses through licensing the intellectual property to third parties rather than selling products. So it does not sell its product or the ownership of Office. When you get Office, you get a license. You don't own the Microsoft Office. So it's usually the idea you will own nothing and you will be happy. Then we also have the manufacturers who usually pay Microsoft a fee in order to install Windows on their machines. Then businesses, they pay the annual 365 license for Office. So ideally what Microsoft has done is built an ecosystem whereby they get money from every end of the divide. And now they've exceeded 3 trillion in market cap. $3 trillion. So now even for you as a startup founder, you need to consider not to sell your technology outright, create licensing models to become scalable. Now, then there's also another important thing to discuss, things like taxation of IP royalties. So now royalties are subject to income tax. That's basically usually what is the easiest approach of doing this. There's usually withholding tax. Withholding tax is not a final tax, but usually given a withholding certificate. Then if you're going to get a withholding certificate, then you're going to justify that, hey, these are the costs that were undertaken in the development of this IP. So now the royalties need to be limited. Now on the international level, we usually have the taxation agreement. So you want to avoid double taxation. So you need to set up your royalties in a manner whereby if you're taxed in one country, you should not be taxed in another country. So ideally what you need to do is look for countries that have double tax avoidance agreements. Countries like Mauritius offer very good tax regimes for Kenya. Now for residences, you just pay the normal way through withholding. Then non-residence payments, so you usually discuss cross-border payments. But ideally, it's important to look at the tax treaties that you have with the other countries and the structures that are there for how you should pay intellectual property royalties. Now, how will you do this in practice and for your startup? So what strategies would make sense for you? Do an IP audit. Sit down either with a lawyer or internally, ask yourself, what are the assets that I own as a startup founder within my business? What are the potential IP assets that I have? What have we invented? What are our brand elements? What is our software? What is our creative content? What is our process? What is our databases? What do we have that we can claim as our intellectual property? Now, for things like trademarks, file immediately. Kenya usually has a fast-to-file system. This means that if you register your trademark before anybody else, then you get it as registered. Then you can secure a patent if you have a patent and you have a very novel innovation. Then in Kenya, we have a challenge with our intellectual property systems and our protections. We don't utilize so much. So what happens is you find that foreigners come, look at the business models that you've done, look at your structures, look at the innovations that you already have, and they go and replicate it elsewhere. Think about M-Pesa, for example. If M-Pesa was able to be patented even before trademarked, at the time that it was invented, we would have so many royalties and benefits within our country. But now, also the challenges, Safaricom then was owned by Vodacom Group, which is an international organization, which then meant that some of the benefits of M-Pesa would get out of the would go out of the country. Then you need to protect your confidential information, secure your software through copyright book of proper documentation, then protect your confidential information. Draft NDAs within your employment agreements, have confidentiality clauses, have restricted access. Not everybody needs to know your everything within your company. Have IP agreements with your employees from day one. Then ensure that you have IP assignment such that the employees, the contractors, the founders, all of you sit down and draft agreements that assign intellectual property to the company and not to the individuals. Because if you have assigned intellectual property to the company, then that means the company has those assets and can calculate it even within its balance sheet. And you can even verify the same before fundraising. Then budget for intellectual property protection, have that cost item, and now also on the other side have a way of getting its benefits from it. Have a budget for the legal costs, the registration costs, the maintenance, so that you also be aware of the value that it brings you. I mean, look at Microsoft, look at Coca-Cola, look at all these businesses and the work that they've been able to achieve through intellectual property protection. Now, the step-by-step process is here. It's really a bit straightforward, but of course, with our firm, we're able to assist you with this. So, trademarks, you have to go to KIPI, look for availability, then you file the application with KIPI, then it takes around 3 to 6 months, and it will be published in the Kenya Gazette, whereby there would be an opposition window for 60 days. If nobody opposes, then you're given a certificate of registration that you use for 10 years. You can renew every other 10 years. Patent, do a search, prior art search. So you look whether there is any art or any work that has been done prior that looks like the same. Then you draft the specifications and claims. Then you file a provisional or complete application at KIPI. Then you can also file the same application at WIPO to protect it on the international level. KIPI can assist you with this. They will look and examine whether it's novel, whether there's an inventive step, and whether there is utility or industrial application. Then it will be published for 3 months during inspection, awaiting for any complaints. Then the patent will be granted. It will be valid for 20 years from the date of filing. Then with that, we have come to the end of our session. So we now have the position to ask for any questions that you might have. At the end of the day, we need to remember that intellectual property for startups is usually one of the most valuable assets. Register, protect your trademarks, file your patents early, ensure you assign patents and trademarks from all founders and staff, protect it, use NDAs and confidentiality clauses, commercialize, and find a way to get licensing, to get revenue, and also consult an IP advocate before fundraising. Once you do some of these things, you'll be able to protect intellectual property. Thank you very much. That has been my time. I will now open the floor for any questions that you might have. Questions? Lenny, how are you?
I'm fine, thank you, Ruben. How are you?
Well. Yes, so any questions about intellectual property?
Yeah, could you elaborate on the tech transfer, the technology transfer, where you're looking at the research output and how to go about that with commercialization?
All right. So regarding technology transfer, what we can talk about is whereby research institutions such as universities usually do intellectual property agreements with the industry to do tech transfer. So, for example, the best example to give would be the University of Nairobi, for example, doing an innovation whereby the University of Nairobi, for example, can do an innovation whereby they have invented a product that they want to utilize. They want to utilize this particular product, but they are, a public institution. Their purpose is education and, such services. What they do is they do a technology transfer agreement, either with a company or two, an industry professional who wants to utilize the same. Then once they do a technology transfer agreement, they then derive the benefits of the intellectual property from the same.
Oh, well, thank you for giving the example. And in fact, one of the issues that I had, especially with UN from a different past experience, is that most of these agreements are not very favorable, and they end up not being a good incentive for even the companies that end up owning this intellectual property. So I don't know whether it's a way to get more favorable terms from these institutions, or that's just how it is in Kenya. That cannot be, battled against, because most of the time the rights that they ask for, in exchange for the legal ownership of some of these technologies is outrageous, and it ends up killing even some of the ventures that need to benefit from some of these technologies being developed in universities.
Yeah, I think that's a very critical question. So how do we then find ways of negotiating with the universities, the research institutions, and the holders of intellectual property? So of course, the biggest problem that we have is bureaucracy and the policies that they have. But ultimately, you need to ask yourself, what are the potential benefits that you can have? And there's usually something we call in negotiation, it's called a BATNA. It's the best alternative to a negotiated agreement. So what you need to ask yourself is, if I get this intellectual property, what would be the benefits that I would derive? If the terms are not very favorable, what would be the best alternative on my end to be able to access some of these things? So usually, especially with public institutions, that usually comes from either a point of policy, and policies can be changed. You just need to do a lot of lobbying with the right people, and policies can be changed in that particular manner.
Yeah, thank you. That answers the question. I think when I get a more specific problem, I'll be able to reach out and we can discuss further.
All right, brilliant. Do you have another question? I hope I didn't cut you short.
No, not really. That was my only question.
All right, thank you very much. Do you have any other questions, Stephen? Okay, so you type. How high? Yeah.
No, we don't have any questions.
All right. How can I access the notes that you shared on the screen? So we are working with some of our developers to be able to assist us to be able to host even some of our presentations and our recording within our website, and then we can also have links to some of our presentations. All right. Lavender, do you have any questions?
Not exactly.
All right, Liched Analytics.
Not at the moment, thank you.
All right, Kite. Brilliant. Ivy, do you have any questions? Perfect. Cynthia, do you have any questions? Edwin, do you have any questions? Perfect. Now, with that, I think that brings us to the end of our webinar today. Thank you so much for your time, for your ears, and I hope that you've been able to learn so much, and potentially you'll be able to see how to protect your intellectual property as a startup founder, how you can commercialize your intellectual property, and how to